Well, today is a pretty big day. A an order by the federal judge, the latest order by the federal judge, Chief Judge Mark Walker, in the Lynn Haven corruption case concerning former Mayor Margo Anderson and developer James Finch, was unsealed just a couple of hours ago. And I've reviewed it. It's about 46 pages, and I am going to share it with you. I'm going to read it with you, to you. And basically, what happened a couple of weeks ago is Judge Walker did two things, two rulings. One ruling is he threw out the biggest count, count one, the conspiracy count, hundreds of paragraphs, as duplicitous. And he issued a second ruling that denied to dismiss the entire case because the standard, I made a few notes here. The court, Judge Walker, cannot dismiss unless there are no less severe sanctions to the misconduct that the defense is claiming, and that Judge Walker has, at least in part, acknowledged. So the judge cannot jump straight to the most severe sanction, which is to throw the whole thing out. He is required by law, according to the ruling, to give a lower sanction. And so it looks like it'll be going to trial. And it looks like that my guess is that'll take place probably late August or September. But I want to share with you the just hours ago unsealed ruling by Judge Walker. Judge Walker calls the investigators and the prosecutors reckless and haphazard. He calls the prosecution's excuse for not providing evidence that could show that Finch and Anderson are not guilty, known as Brady evidence. The judge called their excuses for not providing that in a timely fashion nonsense. He said the government's conduct has been less than laudable and that they failed to follow production orders. This is unbelievable. And that many false statements made to the grand jury by investors or by prosecutors, I guess, and investigators, some of them are deadly serious. And finally, that the government has pursued this case in a fast and loose manner. This is only concerning former Mayor Margo Anderson and developer James Finch. All right. I'm going to be looking at your comments too. I'm going to try to look at your comments, but I'm going to be reading this whole thing to you. You're going to hear all of it. And it will lay out the defense arguments. It'll lay out the government's arguments, and it'll lay out the judge's ruling that denied throwing the entire case out. This is amazing. All right, I'm going to get right to it. As soon as we thank those who allow me to do this.
When your life is on the line, hire the lawyer who lives in our community, works in our community, and worships in our community. I'm El Saulene, your Panama City Beach lawyer. 850-215-0628.
You want to look good? You want to feel good? Little John's Big and Tall is where it's at. Right across the street from Sky's Pizza Pie, 5700 North Davis Highway. You can find out more online at littlejohnsbigandtall.com. He's also a member of the iTex trading community, where your iTex dollars are welcome.
All right. Let's get to it. This will be a lot, but it is. If you've been interested in the Lynn Haven corruption case concerning former Mayor Margo Anderson and developer James Finch, here it is. This is the just hours ago unsealed latest ruling. And let's just start right off. Redacted unsealed omnibus order on motions to dismiss with prejudice. I'm going to read through this. I don't think I need to read the footnotes on this one. All right, so I'm going to read just the narrative. Claiming prosecutorial misconduct, defendants Anderson and Finch moved to dismiss the second superseding indictment with prejudice. Both defendants argue that this court should dismiss the indictment because the government violated discovery orders. They also argue that the government misconduct before the grand jury warrants dismissal. Finally, the defendants argue that the government has intruded into their relationship with their attorneys, thus violating the Sixth Amendment and also warranting dismissal. This court held a lengthy hearing on the issue and has received hundreds of pages of briefing. The motions are now ripe for resolution, though the government's conduct in this case falls well short of this court's expectations. This court finds that dismissal is unwarranted. Defendants' motions to dismiss are therefore denied. As the parties recount, it has been a long journey to this point. This case began nearly 2 years ago. Since then, defendants have been added, such as Finch, and defendants have pled guilty, such as Adam Albritton. This court, that's the former city attorney, this court has also granted in part or whole 4 motions to dismiss and resolved a host of other motions. Because the parties are intimately familiar with this case's history, this court will not set it out here. That said, because it is relevant to this court's analysis before turning to the parties' motions, this court lays out the allegations currently before it. The operative indictment is the second superseding indictment returned on November 16, 2021. It alleges the following. Finch, who owns a construction business, bribed Anderson, then the mayor of Lynn Haven, for favorable treatment related to city projects. Anderson took official actions benefiting Finch and pressured the city manager to do so as well. The city manager has pled guilty. They are awaiting sentencing. Then, after Hurricane Michael's 2018 landfall, Anderson received free services from ECS, a contracting company at the time defrauding Lynn Haven. This included clearing debris from both Anderson's house and her relatives' homes. ECS ultimately billed the city for these services. These are the allegations. These are the charges. Anderson also accepted free and then reduced price services from WorldClaim, an insurance adjusting firm, in return for giving the firm a city contract. Plus, Anderson steered hurricane recovery projects to Finch's companies in return for bribes. Finally, both Anderson and Finch lied to the FBI about the above detailed schemes. Those are the charges. Based on these allegations, the second superseding indictment alleges Finch and Anderson with conspiracy to commit honest services wire fraud. Honest services wire fraud, theft or bribery concerning programs receiving federal funds, wire fraud, and making false statements in a manner within the executive branch of the government. By a separate order, issued along with this order, this court dismissed count 1 with prejudice as duplicitous. That's the conspiracy count, the big one. But this court found the remaining counts facially valid and thus declined to dismiss them. That leaves the motions described above, in which the defendants contend that because of repeated government misconduct, this court must dismiss the entire second superseding indictment with prejudice. Defendants argue that this court should dismiss the second superseding indictment because 1, the government violated discovery orders, 2, the government committed misconduct before the grand jury, and 3, the government violated the Sixth Amendment. The court first addresses the defendant's argument that it must dismiss the second superseding indictment because the government violated discovery orders. When a party fails to comply with discovery orders, the federal rules of criminal procedure authorize this court to, quote, enter any other order that is just under the circumstances, end quote. When contemplating sanctions under Rule 16, this court must consider, quote, the reasons why disclosure was not made, the extent of the prejudice, if any, to the opposing party, the feasibility of rectifying that prejudice by a continuance, which would be a lesser sanction, as I mentioned in the opening, and any other relevant circumstances, end quote. Under this rubric, this court must impose the least severe sanction that will accomplish the desired result. Prompt and full compliance with the court's discovery orders, end quote. This court must also determine and consider whether the prosecutor acted in bad faith, end quote. And finally, this court must always keep in mind that its foremost function is, quote, to hear all relevant evidence in an attempt to reach a truthful and reliable verdict, end quote. The court begins with Anderson's motion. She argues that the government violated this court's orders in 4 ways. 1, it failed to timely provide her with a list of not to be contacted potential witnesses. 2, it failed to timely provide her with all of her recorded statements. 3, it failed to disclose all Brady material, that is, exculpatory material, meaning material that could show she's not guilty. Anytime I say Brady material, that's what we're talking about. It failed, and 4, it failed to comply with an order directing it to provide her with all interview reports and notes. Taking those arguments in order, this court first considers Anderson's contention that, quote, the government failed to timely comply with the court directive to provide her a list of not to be contacted potential witnesses, end quote. At Anderson's arraignment, Magistrate Judge Fitzpatrick ordered the government to prepare a list of persons that Anderson may not contact while on pretrial release. But the government did not provide the list until over 10 months later. This, Anderson says, violated this court's order. In response, the government, prosecutors, quote, concedes, end quote, that it should have provided a list earlier, but argues that, quote, Anderson is in no position to complain, end quote, because she contacted Finch even though she was clearly prohibited from doing so. In other words, the government accuses Anderson of having unclean hands. The problem with the government's argument is that its responsibility to comply with this court's orders does not turn on whether defendants have also complied. And so defendants' violations of court orders, while perhaps sanctionable in other ways, do not excuse the government's failings. That said, the government's failing here was minor. Indeed, Anderson does not even try to explain how the government's noncompliance prejudiced her. So this failure cannot, at least on its own, warrant dismissal. Next, Anderson argues that the government, quote, failed to timely comply with the court order to provide Anderson with all her recorded statements, end quote. To support her argument, Anderson points to this court's August 25th, 2020 order directing the government to produce her recorded statements. Yet Anderson says the government did not turn over any recorded statements until April 2021. The government retorts that the statements at issue relate to allegations to the original, to the superseding from the superseding indictment, and thus the statements were irrelevant to the original indictment. For this reason, the government says it did not initially produce them. Once the superseding indictment was unsealed on March 16, 2021, the government produced the recordings. The federal rules of criminal procedure oblige the government to produce a defendant's, quote, relevant, end quote, written or recorded statement. Here, both sides could raise viable arguments as to why the statements at issue may or may not have been relevant in August 2020. Under these statements, this court cannot say that the government's failure to produce the statements before April 2021 warrants sanctions under Rule 16, especially when the government did produce the statements once they became unambiguously relevant. Anderson also argues that the government violated court orders directing it to disclose Brady material that could show her being not guilty. In multiple orders, this court directed the government to produce all Brady material, stating, quote, counsel for the government shall disclose any evidence favorable to the defendant without regard to materiality within 7 days of arraignment or promptly after acquiring knowledge thereof, end quote. Claiming that the government has violated these orders many times over, Anderson points to the government's 1, July 2021 disclosure of interview reports, 2, November 2021 disclosure of interview reports, 3, February to March 2022 disclosure of interview reports and notes, and 4, April 2022 disclosure of interview reports and notes. For context, the July 2021 disclosures came after this court entered a protective order The November 2021 disclosures came after the court granted a motion to compel. And the February to March 2022 disclosures came after this court granted another motion to compel. Taking each disclosure in turn, the 2021 interview reports and notes, Anderson argues, show that contrary to the government's theory of the case, she did not control city manager Michael White, that she did not request or accept free services from WorldClaim, that she was not involved in ECS-related schemes, that a stormwater easement that Lynn Haven was obligated to clear was located behind her property, that Bay County Sheriff's Office Major Jimmy Stanford, who helped investigate her, received corrupt payments from other alleged conspirators, and that she was not involved in awarding Finch contracts. As for the November 2021 disclosures, Anderson argues that they undercut ECS's invoices reliability and show that Major Stanford received corrupt payments from other alleged conspirators. Anderson also argues that the February to March 2022 disclosures show that she did not control city manager Michael White, that she did not receive services from WorldClaim at a discounted rate, that interview reports and their corresponding rough notes differ significantly, that ECS did not clean up her property, that ECS's invoices are unreliable, and that she was not involved in ECS-related schemes. Finally, Anderson argues that the April 2022 disclosures show that ECS invoices are unreliable, that ECS did not do work on her property, and that she did not request or accept free services from WorldClaim. The government retorts that because Finch provided sensitive discovery material to other individuals who were also under investigation, it waited until this court's July 6, 2021 protective order to produce many reports addressed above. The government further argues that defendants had long known that Major Stanford allegedly received corrupt payments from other alleged conspirators and about the alleged deficiencies in ECS invoices. Thus, the government says documents addressing those subjects were not Brady material, and at the very least, their non-disclosure was harmless. As for the other reports, the government argues at length that they are not, in fact, favorable to defendants or are inculpatory. In other words, exculpatory means that it might be evidence that would show she's not guilty. Inculpatory is the opposite. For example, as to the interview reports related to WorldClaim, the government argues that, quote, the no-fee arrangement was made and discussed with Anderson. This is the only redacted part. So I'm guessing it's with Anderson and another individual who is unnamed. Prior to the signing of the Lynn Haven contract with WorldClaim, but that agreement was not included in the interview notes because it was a short interview, said the government. Based on its interpretation of the reports, the government determined they were not Brady material. To start, this court rejects the government's insinuation that some of the above described documents, for example, the WorldClaim interview notes, are not Brady material because defendants are guilty. That's nonsense. Wow. Judge Walker just said that the government's reasoning for not turning over Brady material is nonsense. But setting that aside, for the vast majority of disputed material, this case provides an excellent example of the uncertainty of Brady-related production. Here's what Judge Walker is saying, or he is quoting case law. Because the defendant is not required to announce the theory, this is the problem with Brady law, according to the judge. Because the defendant is not required to announce the theory of defense, and the prosecution is not required to maintain an open file policy, there is inevitably a degree of uncertainty about compliance with Brady. As the vaunted legal scholar Donald Rumsfeld explained, there are known knowns and there are known unknowns. Who remembers that quote? The problems, however, arise with the unknown unknowns. That was case law and a quote from Judge Donald Samuel. To be sure, for most of the material, both sides could make colorable arguments about why it is or is not Brady material. Thus, the government should have marked the relevant material as an exhibit and submitted it to the court for an in-camera review. But while the government's conduct may have fallen well short of best practices, this court cannot say that the government acted in bad faith. More importantly, given that there is still no firm trial date, that the government has now produced the documents at issue, this court cannot say that Anderson has been sufficiently prejudiced to warrant dismissal. Thus, as to Anderson, the government's Brady shortcomings do not require dismissal. Finally, Anderson argues that the government disregarded a court order directing it to provide her with all interview reports and notes. In so doing, she points to this court's February 2022 order instructing the government to produce, quote, all witness reports and the notes of agents conducting the interviews, end quote, on or before March 1st, 2022. Despite this order, Anderson says the government has produced interview notes as recently as April 13, 2022. While the government bypasses this allegation, the court finds that the government should have complied with the court's order, or as the order required, quote, file a notice explaining why a later deadline is necessary, end quote. That said, as with the other violations discussed above, this court does not find it prejudicial enough to warrant dismissal. Rather, the government must file a notice stating that, to the best of its knowledge, all outstanding reports have been produced, or the government may file a notice explaining why such reports have yet to be produced. Turning to Finch's motion, he too argues, quote, that the government repeatedly and intentionally violated, end quote, discovery orders. Much of Finch's arguments overlap with Anderson's. For example, he points to the government's late disclosure of many interview reports, often sparked by orders compelling production. He also complains about Bay County Sheriff's Office notes that the government produced with little explanation after the evidentiary hearing on this matter. That's amazing. The government, too, raises many of the same arguments in response to Finch. Just as this court finds, in Anderson's case, the government's shortcomings do not warrant dismissal, it finds that they do not warrant dismissal as to Finch either. The court does not discuss every allegation regarding discovery set out in the many hundreds of pages of briefing that the parties have filed. But this court has scrutinized every allegation and every filing. Make no mistake, it agrees with the defendants that the government's conduct has been, to put it mildly, less than laudable. But, as explained above, both the Old Fifth and the 11th Circuits have made clear, crystal clear, that this court may dismiss for failure to follow discovery orders only when there is no less, quote, severe sanction will accomplish the desired result, end quote. That case law also focuses on the prejudice to the defendant. Here, despite this court's reservations about the government's conduct, this court cannot say that the defendants are prejudiced in a way that cannot be rectified by a continuance, or that dismissal is the least severe sanction available under these circumstances. Thus, this court declines to dismiss the second superseding indictment with prejudice for failure to follow its discovery orders. You know, if you're ever arrested in federal or state court, I hope that you get all of the evidence that you're entitled to by law. Because the way the law is set up and the way case law precedent is set up, it's not enough to get it thrown out. Defendants also move to dismiss based on government misconduct before the grand jury. This court may, quote, dismiss an indictment because of misconduct before the grand jury where that misconduct amounts to a violation of one of those, quote, few clear rules which were carefully drafted and approved by the Supreme Court and by Congress to ensure the integrity of the grand jury's functions, end quote. But even then, this court may grant the motion to dismiss only if the misconduct, quote, substantially influenced the grand jury's decision to indict, or when there is grave doubt that the decision to indict was free from the substantial influence of such violations, end quote. One of the few clear rules identified is that a prosecutor may not present false testimony to the grand jury. To prevail on such a claim, defendants, quote, must show that the prosecutor knowingly used perjured testimony or failed to correct what he subsequently learned was false testimony, and that the falsehood was material. All of those things. To emphasize, the testimony must be perjured, not simply false. Quote, an agent's inadvertent giving of false testimony before the grand jury does not warrant dismissal of an indictment, end quote. With this standard in mind, this court turns to defendants' motions. This is Finch now. Oh, it's both of them. Both defendants appropriately focus on the grand jury that returned the operative indictment. That said, they also discuss the other two grand juries, largely to support their argument that the government knowingly used false testimony. Some issues defendants raised are benign. Some are deadly serious. This court takes defendants' arguments in order of severity. In this section, this court discusses issues that it finds are really non-issues. So, for the next couple of pages, the court says, yeah, the government messed up, the prosecution, the investigators messed up, but it wasn't a big mess up, all right? And it's going to continue to get worse and worse and worse throughout this ruling that was just unsealed. The court begins with Anderson's argument that the case agent, FBI agent Lawrence Borghini, falsely testified before the grand jury, quote, that a city stormwater easement was located on Anderson's personal property, but that the city was not responsible for maintaining the easement, end quote. Borghini apparently said that, quote, there was an easement on the property and back of her property, end quote. Calling this testimony false, Anderson points to the Bay County Sheriff's Office, Major Stanford, and Lieutenant Mathis's interview of City Public Works Director Bobby Baker. Baker reported that, quote, the debris on Anderson's property was her responsibility to clean up, end quote. And that, quote, there is an easement on the property behind hers that does not encompass her property, end quote. Anderson also points to surveys showing a stormwater drainage easement behind her property. Anderson says that she provided these documents to the government in January 2021. She also argues that the FBI agent's false statement that the easement is located on her property is material because it, quote, left grand jurors with unrebutted evidence that Anderson improperly requested that extensive work be performed on an easement on her property that was objectively inaccurate, and that inaccuracy is a basis for numerous charges, end quote. The government responds that the court reporter simply mistranscribed the FBI agent's statement. In fact, he said, quote, there was an easement on the property in back of her property. Supporting this argument, the government has provided a certificate of corrections stating that page 92, line 14, should be and should say in. Thus, this court finds that the government did not elicit false testimony about the easement behind Anderson's property. Anderson also asserts that Borghini made false statements about her role as whistleblower. Specifically, she challenges the FBI agent's suggestion that her whistleblowing was unhelpful and self-serving. So here is the U.S. attorney asking the FBI agent these questions in front of the grand jury in order to get the indictment. Question. Now, on or about April 1, 2019, did Ms. Anderson ask the Bay County Sheriff's Office to investigate Michael White's dealing with ECS? Answer. She had brought a piece of paper to the sheriff with some numbers on it and was concerned about the amount of money that had been paid to ECS. Now, this is important because on April 1st, mayor at the time, Margo Anderson, had found out that ECS had charged the city $5 million, had defrauded the city $5 million. She brought this evidence to the sheriff. And in front of the grand jury, the U.S. attorney and the FBI agent made that evidence sound like, quote, a piece of paper with some numbers on it is all. So you see, this is a big issue right here. Question, and Miss Anderson, did she disclose to the sheriff that she asked ECF to perform the work at her residence, not paid for her or by her husband? Answer, by the FBI agents, not at that time. And did Miss Anderson later claim publicly that she made a report to the sheriff's office because she recently learned about the amount of money the city paid to ECS? Yes. In fact, as you indicated earlier, she had authorized several millions of dollars of payments. Is that correct? That is correct, says the FBI agent in front of the grand jury. Anderson argues that the FBI agent's statement that she brought a piece of paper misled the grand jury because it understated her whistleblowing activity's importance. She also offers several exhibits that she asserts show that her whistleblowing played a key role in the investigation of public corruption in Lynn Haven. And she says, while, quote, being a whistleblower is not dispositive proof of innocence, it is certainly a critical fact that may influence a grand jury's decision to indict, end quote. The government responds that the FBI agent's statement is true. Anderson did bring a piece of paper with numbers on it to the sheriff. That's exactly what she did, says the government. And noting that Anderson came forward just after Michael White's arrest, the government asserts that whether Anderson's whistleblowing was truly foundational to its investigation is not black and white. I think they're referring to the arrest of Michael White for his domestic violence, not for corruption. A, quote, suspect under investigation by the grand jury, end quote, has never, quote, been thought to have a right to have exculpatory evidence presented, end quote. That's case law. But that is effectively what Anderson demands. The FBI agent's statement was true, yet Anderson insists that the government misled the grand jury by underselling her whistleblowing activity's importance. Under her theory, this court may dismiss an indictment with prejudice whenever the government declines to present facts to the grand jury in a light favorable to the person under investigation. That is simply not the law. At any rate, as Anderson concedes, quote, being a whistleblower is not dispositive proof of innocence, end quote. Because no charge turns on whether Anderson is a whistleblower, even if this court accepted Anderson's argument, this court could not say that the FBI statement substantially influenced the grand jury's decision to indict, or that there is, quote, grave doubt that the decision to indict was free from the substantial influence, end quote, of his statement. Thus, this statement does not warrant dismissal. Next, both Finch and Anderson take aim at the FBI agent's testimony that when the city awarded Finch the opportunity to finance the 17th Street Ditch project, quote, there was no advertisement or solicitation for additional financing or a competitive bid for any financing, end quote, and that the city attorney, Robert Jackson, was, quote, concerned about financing the work with a vendor, end quote. These statements, defendants say, are, quote, inaccurate, end quote. Defendants first point to city manager at the time, before Michael White, Joel Schubert's interview report. It states that, quote, Schubert checked on the bank rate and bond that the city would need to do the work. A study showed that work would get done quicker, cheaper, and the city would pay less money over time with Finch's offer, end quote. They also highlight Jackson's interview report, which states that, quote, Jackson believes there were bonding issues regarding Finch financing the project, that the note between Finch and the city may be unenforceable, end quote. Finally, defendants claim that the testimony that there was no advertisement, solicitation, or bidding for additional financing, while true, is misleading. They argue that the city did consider additional sources of financing, such as traditional commercial lenders, but that the FBI agent's testimony suggests that, quote, the city gave the financing opportunity to James Finch without considering alternative financing options, end quote. The government retorts that there is nothing false about the FBI agent's testimony. There was no competitive bidding to finance the 17th Street project. Plus, Jackson's interview report suggests that he was concerned about Finch financing the project, or one could fairly interpret it that way. The court agrees with the government. The FBI agent's testimony does not conflict with any interview report, and the government need not adopt the defendant's preferred interpretation of an ambiguous statement. In their reply, defendants point to a new FBI interview with the former Lynn Haven attorney, Jackson, taken after they filed their supplemental brief. While this interview shows that defendants' interpretation is correct, the government did not have that information at the time. And so this court cannot say that the government knowingly used perjured testimony, end quote. Well, turns out that the defendants were correct. Finally, Anderson also challenges the FBI agent's testimony, suggesting that interest on the 17th Street loan was, quote, given and provided to, quote, end quote, Finch, and that the process for financing the project did not comply with the city's procurement rules. While these statements may be objectionable at trial, this court lacks the power to so closely police questioning before the grand jury. In other words, the judge said, I don't have the authority to police what they told the grand jury. It's not within my authority. And at any rate, they do not leave this court grave doubts about the grand jury's decision to indict. Defendants also complain that as to the half-cent sales tax project, the, quote, evidentiary facts alleged in the second superseding indictment are unsubstantiated by evidence presented to the grand jury, end quote, grand jury 3. But because, quote, a defendant cannot challenge whether there is sufficient evidentiary foundation to support the grand jury's probable cause determination, end quote, this court cannot consider this argument. Again, outside the power of the judge, he says. This next turns to the post-Hurricane Michael city rebuild projects. Defendants argue that the FBI agent falsely testified to the grand jury that Anderson tried to steer rebuilding projects to Finch, even though the city could not use FEMA funding to rebuild it if it proceeded under the design-build process that Finch proposed. Quote, now the problem with doing that is under FEMA rules, you have to design build. This is, I believe this is what was told to the grand jury. If you select who you want to do the building, then you negotiate a price after the fact. Whereas under the FEMA process and the reimbursements, everything is known up front and is bid out properly. These statements are inaccurate, say the defendants. Defendants point to city commission meeting minutes in which Anderson said that a design build proposal would not be limited to Finch, but would be, quote, open to any contracting firm, end quote. More to the point, defendants also cite the FEMA Procurement Disaster Assistance Team Field Manual. It expressly provides that, quote, FEMA allows the use of design-build contracts if permitted by state, local, or tribal laws and regulations, end quote. In response, the government points to a video of a city commission meeting in which a commissioner stated that FEMA lawyers told him that the city could lose federal funding if they proceeded with the rebuild project through a design-build process, which is not true, or it's just incorrect. In the same video, another commissioner suggests that the way to not piss off FEMA was to go back to the design-build process. Also relevant, though not cited by the government at the city council meeting defendant's site, the city manager explained that the city could not get a firm answer from FEMA in terms of reimbursement if we go with the design-build method. So Lynn Haven didn't know what the hell they were doing. And it was all new. It was big. Lynn Haven didn't know what they were doing. To which Anderson responded that $10 million in insurance funds were also available and that FEMA consultants may not be on top of their game and that the city has not always received good guidance. 2 points, says the judge. First, to the extent that the FBI's testimony on the issue is even intelligible, it appears to be false. Wow. To the extent that the FBI agent's testimony on the issue is even intelligible, it appears to be false to the grand jury. And the government knew or should have known it was false. But the point the government sought to prove with it was valid. In other words, it was all wrong, but the point they were trying to make to the grand jury is valid, says the judge. Anderson and the city council thought using a design-build method would cost the city its FEMA funds, and yet Anderson pressed ahead. For that reason, this court does not find the FBI's agent's misstatement material. Anderson further challenges the FBI agent's testimony that Crowder Gulf, a vegetative debris hauling company, was told it must, by Anderson's direction, quote, start leaving its vegetative debris or chips in Mr. Finch's pit, end quote. Anderson argues that this characterization is inaccurate. The actual email to Crowder Gulf says, quote, the mayor sent me a text from someone stating that you will start utilizing Finch's pit. Please use this email as a directive to haul all mulch from Lynn Haven to the site for disposal, end quote. Anderson argues that the email, quote, was by no means a directive of Anderson as represented to grand jurors, end quote. The government responds that, quote, the email is documentary evidence that the defendant Anderson directed Michael White, city manager at the time, to have the haulers use defendant Finch's pit, end quote. On this point, the line between misleading and not is sufficiently thin that this court cannot say that the government intentionally misled the grand jury. Next, defendants argue that the way the government questioned the FBI agents about the transfer of a motorhome from Finch to a third party, and then from Finch to Anderson's husband, falsely suggested the motorhome was transferred to the Andersons together. These, again, are questions in front of the grand jury by the U.S. Attorney's Office to the FBI agent, trying to make the case. Question: is this a copy of the bill of sale that Mr. Finch represented to you related to the motorhome, Finch selling the motorhome to the Andersons? Yes, this is it, yes. Now, at this time, in July 2018, the motorhome already was registered to the Andersons. Is that correct? That's correct, says the FBI agent. And that the money was paid 22 months after the actual transfer of the title from Mr. Forehand to the Andersons. Is that correct? That's correct, says the FBI agent. Did she, the notary, have any recollection of notarizing the sale of this motorhome from Finch to the Andersons? Question: no. James Finch told number one he sold in 2006 it as motorhome to Anderson and her husband for $70,000. Is that correct? Yes. James Finch falsely told you that he sold the motorhome to the Andersons and that her husband for $70,000 and paid with a check and the difference in cash. Yes, says the FBI agent. These are questions from the U.S. Attorney to the FBI agent in front of the grand jury. This is about 20 some odd months after the motorhome transfer to the Andersons. Is that correct? Yes, that's correct. Finally, in count 16 is similar to count 15, Mr. Finch offering or agreeing to give a thing of value, namely a motorhome, valued at $5,000 or more to Margot and Lee Anderson. Is that correct? Correct. In response, the government makes 3 points. One, that the second superseding indictment itself accurately describes the transaction. Two, that the motorhome is a marital asset, and thus the characterization is accurate. And three, that Anderson herself referred to the motorhome as our motorhome in public statements. This court finds the second 2 points dispositive. The key here is not who the motorhome was legally titled to, but that Finch transferred the motorhome to Anderson's husband for the couple's enjoyment. Surely defendants do not argue it would be legally permissible to trade a motorhome for official acts as long as the motorhome was legally titled to the official spouse. For this reason, the court cannot say that the government's misstatements were material. Turning to Finch's arguments. All right, we're going to hear Finch's arguments. Now, this is where it's the end of this, you're not going to believe. The end of this, the judge really rebukes the investigators and the prosecution. And you'll see why as I continue with this. But I want to take this moment to thank my sponsors. Don't let back pain and neck pain get you down. Find relief at Brown Chiropractic Center on St. Andrews Boulevard in Panama City. Dr. Sherry Brown helps people heal naturally with chiropractic adjustments and deep tissue massage. Call 769-3777.
It's a hot time in Florida, and my friend Ryan can make sure your air conditioning is running at peak efficiency. He could even install a new one, built to a higher standard, American standard. Find out more at pcairrepair.com.
All right, now the judge is going to address Finch's arguments from least convincing to most convincing. So here's where it's going to start progressively getting challenging for the government, I believe, for the prosecutors and the investigators. Turning to Finch's arguments, he complains that the government referred to other grand juries before the latest grand jury testimony, telling them those juries had returned indictments. He also claims that the government, quote, repeatedly asked the FBI agent leading questions about prior indictments, charges, and guilty pleas, end quote. Finch says that, quote, had these types of questions been asked during trial, objections would have been sustained and the court would have likely mistried the case, end quote. Finch further argues that the government's repeated references to prior indictments, other charges, and guilty pleas led the grand jury to rubber stamp the second superseding indictment after less than 2 minutes of deliberation. Finch relies on the 11th Circuit's decision in prior case law, which held that pressuring a grand jury to indict, quote, out of deference, end quote, to previous grand juries is improper. But that case, says the judge, is not binding and is distinguishable. In other words, it's apples and oranges. The judge says, in that case, the prosecutor told the grand jury that the previous grand jury just wanted to indict. This violated federal rule of criminal procedure, which prohibits the disclosure of matters occurring before the grand jury and is, quote, one of those few clear rules which were carefully crafted and approved by the Supreme Court and Congress to ensure the integrity of the grand jury's functions, end quote. Put another way, the problem in that other case was that the prosecutor disclosed a previous grand jury's opinion of the case, not just that previous grand juries had considered the case. Quote, disclosure to the third grand jury that 2 previous grand juries had considered the case was proper, end quote. Plus, the judge says, as the government correctly points out, leading questions before the grand jury are not enough to invalidate an indictment. And Finch comes forward with no authority, providing the government cannot inform the grand jury of guilty pleas. Thus, this court finds that these arguments do not support dismissal. Finally, Finch argues that the government impermissibly mentioned to the grand jury that Finch was paying Anderson's attorney fees, claiming that this court had vowed to declare a mistrial if the government did so before the petite jury. But that was not what this court said. This court said that it would declare a mistrial if the government suggested that defense counsel somehow violated the law or other ethical obligations. In other words, if the prosecutors said that the defense attorneys had broken the law, then Judge Walker said he would have declared a mistrial. But Judge Walker said that's not what happened. Referring to a suggestion from the government that an attorney had lied to the FBI and stating, quote, it is a serious, serious allegation to come into a courtroom and there to be an implication that a lawyer has done something untoward, end quote. The judge wasn't having any more of that. By contrast, at Anderson's conflict waiver hearing, at the government's request, this court specifically warned Anderson that, quote, there is a possibility that the payment could be introduced into evidence. I'm not prejudging the issue whether it would or would not be, but you understand that it could be introduced, end quote. This court continued, quote, do you understand whether or not it's explicitly told to the jury or not that the jury may be thinking about that? If it were told that or learned of that, they may view your lawyers and hence your defense differently, end quote. This court did not rule that payment to attorney was absolutely off limits. And in the absence of any other legal authority supporting Finch's argument, this court finds that these references are not government misconduct. Finch also charges the legal instructions given to the grand jury. Challenges. First, Finch complains that the government told the grand jurors that, quote, the concept of honest service is a little bit tricky or counterintuitive, end quote. But that is an accurate statement, says Judge Walker. Indeed, Finch does not argue that the government misconstrued that the grand jury on honor service is wire fraud. Finch also takes aim at the government's instructions on conspiracy. Here's what the U.S. Attorney's Office told the grand jury regarding conspiracy. Quote, and I realize I forgot that there's a conspiracy charge. I'm pretty sure you all had a conspiracy case already. Here, the conspiracy is to commit the honest services fraud, as I described. And again, a conspiracy charge requires proof that there was an unlawful plan and the defendant willfully joined in the plan, end quote. Finch argues that a conspiracy requires 4 things. Number 1, 2 or more persons in some way agreed to try to accomplish a shared and unlawful plan. 2, it has to include all of these. 2, the defendant knew the unlawful purpose of the plan and willfully joined in. 3, during the conspiracy, one of the conspirators knowingly engaged in at least one overt act as described in the indictment. And 4, the overt act was committed at or about the time alleged and with the purpose of carrying out or accomplishing some object of the conspiracy, end quote. And that is a standard put forth in case law. Thus, says Finch, the government, quote, excluded necessary elements of knowledge and performance of an overt act in furtherance of the unlawful agreement, end quote. The government responds that the second superseding indictment charges conspiracy under the law, which, as the pattern jury instructions show, does not require an overt act, requiring instead that, quote, 1, 2 or more persons in some way or manner. I'm not going to read this because the judge ended up throwing this out for duplicity. I might as well read it. We're here, right? 1, 2 or more persons in some way or manner agreed to try to accomplish a common and unlawful plan to commit mail fraud as charged in the indictment. And 2, the defendant knew the unlawful purpose of the plan and willfully joined in it, end quote. Okay, that's from case law. Quote, a conspiracy charge under section 1349 does not require the commission of an overt act, end quote. This court therefore finds no issue with the government's instructions to the grand jury. Okay, so I'm glad I read that. All right, here we go. The court finds that all of the issues described above are either non-issues, such as the FBI's testimony about the easement, or not enough to create grave doubt about the grand jury's decision to indict, such as FBI agent's testimony about the 17th Street Ditch project. Thus, taken alone or together, these issues do not form a sufficient basis to dismiss the second superseding indictment. Okay, now that the judge has gone over what he considered the defense's weakest arguments, he's going to start considering what he considers moderate and very strong arguments to dismiss the case. Here's where, on page 29, we've got about probably 14 more pages, 12 more pages. This is where it'll begin to get hot and heavy. Having discussed, the judge says, what it considers minor or non-issues, this court turns to the meat of the defendant's arguments, namely, the issues that do not give this court pause. Namely, the issues that do give this court pause. Excuse me. This court proceeds by explaining each allegation and the government's response. It then concludes by addressing whether they warrant dismissal, and this court begins with testimony that the government presented to the first two, but not to the last, grand jury. Before the first two grand juries, the government inquired into a good job text message about a good job, in a way that Anderson alleges mischaracterized the message's content. She acknowledges that the text was, quote, was not an issue before the grand jury, end quote, grand jury 3, but that she argues that, quote, its presentation to prior grand juries demonstrates a pattern of misconduct, end quote. The text exchange at issue says the following. This is between city manager Michael White and ECS owner Mickey White, not related. City manager, dude, I think I got you a good job via the mayor. The contractor, okay. City manager, we've been talking about cleaning every side road in Lynn Haven. That's about 112 miles. Before the first grand jury, FBI agent describing these texts as a communication, quote, that the mayor has some really good as a possibility for Mickey White, end quote. This characterization apparently carried over to the second grand jury. While this testimony is technically true, in context it was misleading, says Judge Walker. The government led into its questioning about the good job text message with questions about work ECS allegedly did at Anderson's house. So they conflated issues about the good job. That suggests that the good job was a reward for ECS cleaning Anderson's house. But as FBI agent's testimony before another grand jury makes clear, the city manager was merely telling the contractor that the city planned, quote, to actually bid out a contract, end quote. Although the way the government presented this testimony to grand juries 1 and 2 accords with the fast and loose way the government has pursued this case, the court does not find that it suggests bad faith on the government's part. The court now turns to defendants' allegations of misconduct before the latest grand jury. First, this court addresses Anderson's argument that the FBI agent falsely told the November 2021 grand jury that she had approved checks issued to ECS. Before the grand jury, the FBI agent testified that, quote, Anderson would approve an account payable report that would show various payments of significant sums of money to ECS, end quote. He also testified that each city check run, quote, has specific signature blocks where it's calculated to people approving the check, such as Mayor Anderson, the city manager, and the finance director, end quote. Finally, the FBI agent told the grand jury that Anderson, quote, had authorized several $1 million worth of payments, end quote. Challenging these statements, Anderson points to the 2019 interview of Amanda DeLonghe, an accounting specialist for the city of Lynn Haven, and to an affidavit supporting a warrant to search city manager Michael White's phone. In her 2019 interview, DeLonghe told the FBI agent that, quote, after each check run, a check register of the checks issued would be printed off and sent to the mayor, who would review and sign off on the check register so that she would be aware of how much money the city was spending. Similarly, the search warrant application states that the mayor of Lynn Haven had not signed the checks to ECS. But for the FBI agent's false statements, Anderson said, there was no evidence presented to the grand jury supporting the allegations that Anderson approved or authorized ECS invoices and payments, and no evidence that Anderson contributed to or participated in the ECS scheme. Remember, this is what she blew the whistle on. This is what she took to the sheriff's office, the piece of paper with numbers on it. In response, the government points to the FBI agent's testimony of the grand jury that the city does a twice monthly check run, quote, after which a report is generated and distributed for approval by Mayor Anderson, end quote. Plus, the government says Anderson is not charged with approving checks. Rather, the check registers are relevant only to show that Anderson, quote, had knowledge of ECS's role in the cleanup, contrary to her statement to the FBI, end quote. In short, Judge Walker says, although the government does not concede that the FBI agent testified falsely, assuming he did, it argues that his testimony was immaterial. Anderson also accuses the FBI agent of falsely testifying before the grand jury, quote, that the city manager, Michael White, did not have personal properties of city employees cleaned up after Hurricane Michael, end quote. Rebutting a letter Finch wrote defending Anderson, the FBI agent told the grand jury that the city manager, Michael White, had city employees try to mitigate potential damage at on-duty police officers' homes, but not to clean them. Here's what he said. Finch also indicates that it's common knowledge throughout the city that the city manager had property of every city employee cleaned after the hurricane at no charge. Every one of them. This includes all of the policemen, yet the government is charging Margot that she had her property cleaned up without paying for it. No. What the city manager did do, however, though, was because his police officers were having to work long shifts every day with no day off and so forth, and all their properties were damaged and so forth, he did get some of the city employees, the building department guys, to run by their houses and throw up tarps on their roofs so their personal belongings would not be destroyed. Anderson argues that this statement is false, misleading, and substantially influenced the grand jury to indict. To support her argument, Anderson points to 4 interview reports. The first is an interview report detailing one of Michael White's interviews. It states that, quote, White sent Lynn Haven Director of Facilities Robert Brannon to all the city employees' houses to have their employees' roofs tarped and assist with whatever else they could assist with, end quote. And a report from another of White's interviews, these are interviews with investigators, that, quote, White directed ECS to move some stumps at Lynn Haven police officer Mac Williams' house. White did this for Williams and some other police officers because they were having to work long hours and needed assistance with their personal residences, end quote. Next, An interview report for Lynn Haven facilities employee David Horton says that, quote, the department heads were directed to gather a list of city employees whose residences had been damaged. Brandon and Horton were to take crews and tarp a city's employee houses on the list, end quote. Finally, an interview report from Mickey White states that, quote, after the hurricane, ECS went to a few police officers' residences to work, end quote, and the city paid them for the work performed. The government concedes that FBI agent Borghini's testimony was not accurate, but argues that the testimony, quote, did not substantially influence the grand jury's decision to indict, end quote. The government argues that even if the contrast is not as stark, there is a meaningful difference between providing tarps and removing a few stumps from completely clearing Anderson's lawn as well as her family members' lawns. Turning to Finch, he points to a timeline of events presented to the grand jury supposedly showing the city commissioner Barnes' votes at the city commission relating to Finch. The timeline states that at a March 14, 2017 commission meeting, Barnes seconded a motion to sell land to Finch and voted for a change order for the 17th Street project. The next day, it says, Finch wrote Barnes a $2,500 check. All parties concede that the vote actually occurred February 28, 2017. Beforehand, the government responds by emphasizing that, quote, the second superseding indictment accurately puts the date on the vote on February 2018, 2017, and accurately notes the city manager recommended the action. End quote. City manager. Plus, says the government, given that the check at issue concerned only $2,500 out of $42,500 that Finch allegedly paid to parties, Finch cannot show that the misleading exhibit substantially influenced the grand jury's decision to indict. Finally, Finch also challenges that the government asked before the grand jury the questions. He challenges the questions asked. For example, Finch challenges questions soliciting testimony that Anderson ran for mayor on a platform advocating a strong mayor. It's a form of government different than what Lynn Haven has now. They have a strong city manager form of government, and that she would, quote, fire people. But Finch says the worst question was, this is what was presented to the grand jury. I think Mr. Finch's counsel also wanted the grand jury to know that Phoenix, Mr. Finch's company, was awarded over $700 million of government construction contracts, and less than 8% of these were awarded by the city of Lynn Haven in the past 40 years. Is that significant to you that 8% was obtained fraudulently? I was asked to the grand jury. Thus, says Finch, the government insinuated that Finch had fraudulently obtained over $56 million in government contracts over 40 years with absolutely no legal or factual basis. Even worse, the government asked the same question before earlier grand juries. The government concedes that, quote, the question was based on a factual premise not supported by evidence presented to the grand jury and should not have been framed that way, end quote. The government itself says it shouldn't have been asked that way. And in its defense, all the government can muster, says Judge Walker, is to assert that the misstatement could not have influenced the grand jury because the FBI agent attempted to correct the misstatement when he responded to the question. Having laid out the most severe violations before it, this court now considers whether they warrant dismissal. The grand jury is entitled to, quote, extreme autonomy, end quote, and the government need not present exculpatory evidence to the grand jury. Even so, a grand jury proceeding is not an anything goes affair. But here, the record before this court suggests that the proceedings in this case have come perilously close. For 3 of the 5 issues discussed above, the government concedes that the testimony or question at issue was, at best, misleading, or at worst, outright false. Still, the government argues that its misstatements did not influence the grand jury's decision to indict. To be sure, this court, says Judge Walker, does not find all of the FBI agent Borghini's misstatements influenced the grand jury. Not all of them. For example, this court agrees with Anderson that the way the government presented the FBI agent's testimony regarding checks was misleading because it suggested that Anderson approved the checks before the city issued them. But this court also finds that the FBI agent did not lie to the grand jury. He told the grand jury that Anderson, quote, approved the accounts payable report, end quote, and, quote, authorized payments, end quote, not that she signed the checks. Further, this court finds significant that the indictment does not charge Anderson with authorizing every false payment to ECS, just those payments related to the cleanup at her property. Recall that defendants, quote, must show that the prosecutor knowingly used perjured testimony, end quote, and that the testimony was material. While Anderson comes close on this point, says Judge Walker, this court cannot say that she has met that burden. On the other hand, the government readily admits that the grand jury heard false testimony suggesting that the city did not have employees' houses cleared, as Anderson's was, and that Finch paid Commissioner Barnes $2,500 only a day after Barnes took action that favored Finch, even though the payment and the action were actually roughly a month apart. The government also readily admits that it asked a question twice, quote, based on a factual premise not supported by evidence presented to the grand jury, end quote, suggesting that Finch had fraudulently obtained over $56 million in government contracts over 40 years. These statements raise concerns about the grand jury's independence, and for each, the government's responses are exceedingly weak. For example, Judge Walker says, as noted above, as to the commission vote, the government says no harm, no foul, because the second superseding indictment itself sets the correct dates. But the government seriously underestimates how serious this is. That the indictment bears the correct date for the vote in question only makes the misstatement worse, as it suggests that the grand jury merely took the government's word for it, rather than checking all allegations in the indictment against the evidence presented. Ultimately, however, here we're getting to the end here. You're not going to believe what I'm about to read you. Ultimately, however, what saves the government is the distinction between incompetence and malice. Quote, an agent's inadvertent giving of false testimony before the grand jury does not warrant dismissal or an indictment. That's case law. Although an extraordinary close call, says Judge Walker, based on all the evidence before it, this court finds that the FBI and the government were reckless, careless, and unprofessional. But this court does not find that they intentionally misled the grand jury. Thus, this court finds that misconduct before the grand jury does not warrant dismissal with or without prejudice. Judge Walker said there was misconduct before the grand jury, but it didn't rise to that level because he has to use other less severe sanctions first. Defendants also argue this court must dismiss the second superseding indictment, the whole thing, because the government violated their Sixth Amendment right to counsel by having an informant contact defendants and discuss their case-related issues. Defendants' arguments center on Gregory Wilson, a former state attorney and close friend of unindicted co-conspirator Derwin White. In June 2020, Bay County Sheriff's deputies arrested Wilson on suspicion of workers' compensation fraud. Immediately after his arrest, Wilson met with the FBI agent. As a result of that meeting, sometime in July 2020, Wilson signed an immunity agreement stating that he would provide information about public corruption in the Panhandle. Wilson testified that after he reached an immunity agreement with the government, he continued to meet with the FBI agent to give him, quote, current information, end quote. Roughly a month later, the grand jury returned an indictment against Anderson. Then in February 2021, Wilson began working at Derwin White's firm, GAC. A month after that, a second grand jury returned an indictment against Finch. At some point, though it's not clear when, Finch and Derwin White entered into a joint defense agreement. While Wilson was working at GAC, Finch would come in and talk to Derwin White on a daily basis, often about matters pertinent to this case. Wilson's office within GAC was directly adjacent to White's, and Wilson would overhear Finch and Derwin White's conversations, Wilson never asked questions or participated. That said, he would ask questions of White after Finch left. He would then relay things he had learned from these conversations to the FBI agent, depending on what Borghini asked. At one point, the FBI agent instructed Wilson to find out the contents and the later location of a box in Derwin White's office marked attorney-client privilege. Wilson also apparently participated in phone conversations with Finch and his lawyers. Based on the above, Finch argues that, quote, the government violated the defendants and other represented parties' constitutional rights by obtaining communications and information pertaining to trial preparation and trial strategy originating from joint defense group communications between defendants and their counsel, end quote. Anderson joins in Finch's argument, reasoning that because many charges against Anderson are mirror image charges against James Finch, and because shared defense strategies or evidence were discussed, a violation of James Finch's Sixth Amendment rights would effectuate a violation of Anderson's Sixth Amendment rights. With this background in mind, the court sets out the applicable legal standard. The government violates the Sixth Amendment right to counsel whenever it interrogates, after a grand jury returns an indictment, a defendant, quote, without the protections afforded by the presence of counsel, end quote. This is so whether the interrogation is direct or surreptitious. Quote, thus the Sixth Amendment is violated whenever a government informant actively engages a defendant in conversation that is likely to elicit incriminating statements about the defendant's upcoming trial, end quote. Based on case law. It implies the government does not violate the Constitution every time an informant hears or reports incriminating information. The key distinction, says Judge Walker, between the Sixth Amendment violation and compliance is whether the informant acted to elicit the incriminating statements. Quote, a defendant does not make out a violation of the Sixth Amendment simply by showing that an informant, either through prior arrangement or voluntarily, reported his incriminating statements to the police. Rather, the defendant must demonstrate that the police and their informant took some action beyond merely listening that was designed deliberately to elicit incriminating remarks, end quote. That's from case law. Thus, quote, in order to establish a violation of the Sixth Amendment, end quote, Finch and Anderson, quote, must show that one, Wilson was a government agent, and two, that Wilson deliberately elicited incriminating statements, end quote. Defendants must show that a violation occurred. The burden then shifts to the government to show that the violation did not prejudice the defendants. In other words, make them look guilty. Applying the test set out above, this court has little trouble concluding that Wilson acted as a government agent. That is something, by the way, when I was in court about 3 months ago, or 3.5 months ago or so, the prosecutor and the FBI agent said Wilson was not an informant. The judge here says, yes, he was. Wow. The more difficult question for the judge, he says, is whether Wilson deliberately elicited incriminating statements. It appears that Wilson did not actively elicit the vast majority of information he obtained. He overheard White and Finch speaking in the office next to him, and Derwin White showed him what was in the attorney-client privilege box without him asking. Plus, there is no evidence before this court suggesting that Wilson did anything during his calls with defense counsel to elicit trial strategy. Wilson's discussions with Derwin White and Derwin White's conversations with Finch, however, are more problematic. Wilson testified that he would ask questions after Mr. Finch would leave. When he asked questions, Derwin White would then generally open up about a whole bunch of stuff, end quote. But Derwin White was never indicted. This is an important point. And so the Sixth Amendment's contours here are hazy. Even accepting that Derwin White had a joint defense agreement with Finch, luckily, this court need not go there. And that's because, unfortunately, Derwin White passed away. I don't remember how long ago, but almost a year ago, before he was ever indicted, if he ever would have been. So the court doesn't have to consider that. even assuming without finding that a Sixth Amendment violation occurred, quote, Sixth Amendment deprivations are subject to the general rule that remedies should be tailored to the injury suffered from the constitutional violation and should not unnecessarily infringe on competing interests, end quote. For example, the judge says, quote, law enforcement officers improperly overheard a pretrial, this is a case law that he's leaning on. Law enforcement officers improperly overheard pretrial conversations between a defendant and his lawyer, end quote. And while the court found that the government's actions in that case violated the Sixth Amendment just by the officers overhearing it, it did not dismiss the indictment. This is important. Rather, the remedy characteristically imposed if the prosecutors or the police overhear attorney-client privilege is not to dismiss it, but to suppress the evidence that it gained. That holds true here, says Judge Walker. Wow, wait till you hear what's coming now. About 3-4 more pages. That holds true here. Assuming that the government committed a Sixth Amendment violation, that violation does not warrant dismissing the second superseding indictment, the whole thing. Instead, that violation would warrant suppressing the fruits of the government misconduct. Because no such motion is before this court does not address the issue at this juncture. In sum, the vast majority of conduct defendants complain of did not violate the Sixth Amendment. That said, some conduct may have violated the Sixth Amendment. But because the appropriate remedy for such violation would be to suppress the government's ill-gotten evidence, this court need not determine whether a violation occurred. Assuming it did, dismissal is unwarranted still. Finally, this court addresses cumulative misconduct. And according to case law, quote, it is well settled that district courts may exercise their discretionary power to dismiss an indictment on grounds of prosecutorial misconduct where a sufficient showing of prejudice has been made. But it's equally well settled that, quote, dismissal of an indictment for prosecutorial misconduct is an extreme sanction which should be infrequently utilized, end quote. Whether to dismiss based on prosecutorial misconduct is a discretionary call, according to case law. Dismissal is typically warranted only when the government has engaged in, quote, egregious, flagrant misconduct. Such conduct violates the Constitution if the government's techniques are, quote, so outrageous that it is fundamentally unfair and shocking to the universal sense of justice mandated by the Due Process Clause of the Fifth Amendment, end quote, citing case law. This court evaluates such conduct under the totality of circumstances. The 11th Circuit recently noted, quote, this defense has never succeeded here or in the Supreme Court. So, in other words, even if the government prosecutes you with misconduct, defenses have never succeeded with that. Isn't that something? While the government's conduct, now this is Judge Walker talking about this case. While the government's conduct has been lacking, unprofessional, and unbecoming, it simply has not been, quote, so outrageous that it fundamentally is unfair and shocking to the universal sense of justice mandated by the Due Process Clause of the Fifth Amendment. This is the last page, and this is the crescendo. Now, even though we just found out that no defendants ever won based on prosecutorial misconduct, according to the law, they're supposed to uphold, they're held to a higher standard, which is not true, but that's the law. Quote, prosecutors must hold themselves to a higher standard, end quote, and quote, as they carry out their duty to seek justice, they must strive to conduct themselves with the utmost professionalism, end quote, citing case law. Now, you ready for the crescendo? Though this court, right now in the Lynn Haven case, Judge Walker says, though this court declines to dismiss the second superseding indictment, none should mistake this order as an endorsement of the government's conduct. The government's reckless, haphazard approach is testing this court's patience. More importantly, it is approaching a threshold beyond which defendants are so prejudiced by the government's conduct that this court will have no choice but to dismiss the indictment, the whole thing. This court has now granted, at least in part, 4 motions to dismiss. The government does not get unlimited bites at the apple, although this conduct, by separate order, granted without prejudice part of the defendant's motion to dismiss, the government must take heed. If it chooses to pursue and ultimately secures another faulty indictment, dismissal may come with prejudice. Indeed, at a certain point, when the government cannot return a facially valid indictment despite having 3 opportunities to do so, one may begin to suspect that the issue is with the government's case, not its draftsmanship. It is ordered that the motion to dismiss, however, is denied. The government chose not to pursue count 1 again. They're going to go to trial without count 1. All right. Amazing stuff. This was just unsealed a couple hours before I went live with you. I want to take a look at your comments, and I also want to remind you about the good work being done by Americans for Prosperity. Americans for Prosperity is the largest grassroots organization advancing policies that help people improve their lives. AFP Florida seeks to end corporate welfare, expand energy options, and reform education and healthcare by giving people more choices. Sign up today and volunteer at americansforprosperity.org. If you would like to support my efforts to bring you all of the information and the truth as best I can, here's how you can do it. You can become a patron. It's a big deal. It matters to me. You can become a patron for as little as $5 a month. It's like giving a tip. It's easy, it's anonymous, and you can quit at any time. Patreon.com/Bernie Thompson. This is the sort of crowdfunding that allows me to do what I do, as well as my sponsors, to include, of course, The Unknown Patriot. Thank you to The Unknown Patriot for supporting my work. I hope you have a good weekend, and I will be back with you as soon as I get more information about this or anything else. See you soon.